This is an interesting question, and it's complex, but we're gonna rattle through this. Okay, you have a few questions about attending a mediation or after attending a mediation, and in the issue on the agreement, or the agreement is not signed by the parents. They're concerned with some of the terms and the conditions, and the attorney that's assisting the parents does not want to help or make minor changes to the agreement. Which I'll get to that. I mean, if you participate in a mediation, then you know mediation is intended to be a one-time event, okay? And so if the terms have already been determined and everybody agreed to it, and then the parent, after everybody left and went home, decided that they weren't happy with it, then I tell you what, it just it's not intended to work like that. A mediation is finalized on the day that everybody is there. At least that's how most of them, that's how it's they're supposed to work, according to this area. So I'm not clear on the scenario behind that, because that might be why the attorney is saying, hey, we had an agreement. This is what we agreed to with the school district, and my hands are tied, so to speak, to where I can't make any changes. But like I said, there's not enough there for me to definitively know that. But that's what I want to put out there. Okay, is there a difference between a psycho ed special education or a psycho ed assessment? No, there's no difference between the two. Okay, it's just how they're worded. But I'm also going to get into that. I have a child who has high functioning autism with social, emotional, and sensory processing disorder. Or sensory integration. Can a parent choose an evaluator of their choice and not from the school district approved independent assessor list? We'll get to that. What is a BLL? I don't know what state you live in, so I don't know what that acronym is. I'm assuming it's a behavior interventionist, and they're not the same as a licensed behavior analyst. It's sort of made up positions, that doesn't come with licensure or certification. So I'm assuming that's what a BLL is, somebody in the behavior field. But once again, I don't know that acronym because I don't know what state you live in. What if an agreement includes a request for prejudice dismissal? How can a parent make sure the party who is compensating keeps their promise? Okay, now let's work backwards. As far as requesting prejudice dismissal, a lot of schools will push for that with our cases, and generally I don't care. It doesn't matter. To dismiss with prejudice is normal if you have an agreement. It's just not abnormal, because what ends up happening is that whatever you're getting in the terms of the mediation corrects or satisfies or is basically the corrective action for whatever happened prior to your request for mediation. So it would basically shut your rights to be able to continue to claim or assert that FAPE was denied for your child moving backwards 2 years. Okay, unless you live in North Carolina, then it's 1 year. All right, but every other state's 2 years. So that's all that means, is that your mediation agreement and the terms that you guys came up with solves all of the issues moving backwards 2 years, because that's your statutory limitation. All right, it does not stop your rights moving forward. So the day after mediation, your FAPE rights start all over again, and a school who has 100% of the legal duty to provide your child a FAPE gets an opportunity to screw up all over again. Okay, so your rights move forward. With these agreements, it solves and settles everything moving backwards. All right. So having something dismissed with prejudice, I would only say that that's okay if you have an agreement. All right. But we'll have cases to where the parents are like, you know what? I want to pull my due process complaint. I don't want to continue. For whatever reason, let's say they move, or let's say that we're going through the process and and things come to light. Some things are premature that we didn't think about or that we didn't consider at the time. The full breadth of the school education records came to light, and we were like, this needs to happen and that needs to happen. And so in those instances, my firm will recommend to the parent to go ahead and just pull the complaint. Let's just withdraw it. All right. But we will withdraw it without prejudice, meaning that we are retaining the parent's rights for everything that happened within that statutory period. Okay. Now understand that the parent may be in a position to refile after whatever is corrected or becomes ripe happens, and they'll have that opportunity to refile. Now, the statutory guide still goes on. So let's say they lose 6 months if they file again in 6 months, but still, they're still within that statutory period to be able to complain and get corrective action or remedial services for whatever happened. Okay. So, but if you have a mediation agreement, a resolution agreement, a settlement agreement, whatever it is, then agreeing to dismiss with prejudice is not uncommon in this process. But I just explained to you, it doesn't hurt you moving forward. And if you got good corrective action, it doesn't hurt you moving backwards either. You got corrective action. Okay. Now the other question is, then what can I do to make sure that they do it? Well, you can't. That's what your legal agreement is for. But what makes legal agreements different than an IEP is an IEP is sort of it's a legal document, and people go, oh, it's a contract. Well, it is, but it's a flexible contract. But the other thing is, guys, that's what your dispute resolution options are for. And many parents are going, well, this is a contract. This is a contract. Well, yes, but what do you do if somebody violates a contract? It doesn't repair itself. You have to trigger one of your dispute resolution options to assert that they did not follow the IEP. Your child did not make tangible, measurable progress. Your child stagnated. Your child regressed. That is how you turn your IEP into a legal contract or a corrective action in the form of a due process or mediation, to where the school comes and says, okay, we'll do X, Y, and Z for you. A lot of them won't even admit they did anything wrong. A lot of them will sit there and say, well, the cost of litigation or what, who cares? Ho-hum BS, don't care. Did you get what you needed to for the corrective action? Too many parents are so focused on wanting some admission of guilt, and they're not going to do it because they have attorneys. There are some school districts where the administrators will apologize and say, we stubbed our toe. I respect them a lot. But I don't expect them to tell my client that all the time, because they have attorneys, just like parents have me. Okay? And they're advising their client, do not admit that you did anything wrong. And that's just what the lawyer business is about, guys. Don't get all hung up over it. Did you get corrective action? That's all that matters. And then within that, was there a signature from the school system and a signature from you? And if it was a mediation agreement, guys, or a resolution agreement, either one of those, you don't have to do anything else. Those things are enforceable in federal court. See, now you have an agreement that just by the terms in and of themselves, you can assert that they violated that in a court of law. You don't have to go through the dispute resolution options again, meaning you don't have to go through mediation. You don't have to go through due process. If you have an agreement in the form of a mediation agreement or a resolution agreement, then at that point, if they're not following it, you can go straight to federal court, because this is a legal contract. The IEP is, but it's a flexible, malleable kind of, because you can call as many IEP meetings as you need. And the determination of whether your child is provided a FAPE starts here and ends here. And you do an analysis and you go, okay, well, my child had, and sometimes it's easy for you to figure out 4 months into the school year, especially if behavior and other things are involved. If it's just purely academic, it's a little risky to sit there and make a half-year claim that IEP isn't providing your child a FAPE, okay? So let's keep moving backwards. Do you have to choose an evaluator of their choice, or from their list, or of your choice or from their list? And I can tell you that the schools in the states are by the feds, they encourage the schools to have a list of independent evaluators, for parents to look at. They're not mandated to follow, the people off that list. They're just not. Okay. Now, the schools provide that list because there's a lot of parents out there that are like, I don't have the first clue what behavior analyst is good in this area. I have no clue who a speech language pathologist in this area would be. So it's merely supposed to be a resource of convenience for parents that don't know who might be available out there. But if you do, if you have people in the back of your mind that are like, I want to use this person for a psychological evaluation, a psychological assessment, it really doesn't matter. And the other thing is, I said earlier that they're one and the same. Well, I don't have enough detail in your thing to sit there and really definitively say, yeah, psychoeducational evaluation is the same as a psychoed um, assessment. Okay. I would need to sort of know what those things are called. Okay. But by and large, it sounds like it's the same thing. Okay. And for the, let's say a psychological could be for IQ, for, meaning that they're testing cognitive intelligence, achievement is their performance. Then you have, let's say, behavior or adaptive behavior rating scales that the school staff that know your child and you can fill out. Speech language. If you do language, then I would include pragmatic communication, which is social communication. Not all schools will do that. OT, if your child has sensory issues, expand it to include sensory. And then I also, depending on the setting for your child and the impact of the sensory, I will also request a functional assessment by the OT, which is the OT observing the child in their different environments and how they interact with things, fine, motor, gross, and, sensory, those kind of things. A functional behavior assessment, behavior intervention plan comes from the functional behavior assessment, but who does that is very important. So no, you don't have to choose from their list unless you don't know anybody. But you still don't have to. You can go do the research yourself. The only thing that the school can do is limit your choice based upon a very limited, what's called an agency criteria. Every school is supposed to have an agency criteria. A lot of schools don't. That's dangerous and stupid on the school's behalf. But the only thing a school can really limit you on is radius. How far away is your professional from the school? Usually they can limit it to about 100 miles. That's standard. The other thing is, how much does your professional cost? They can limit that. It's got to be the community rate charged by similar professionals, which I haven't known any professionals that are outside of that realm. So that's the other one. And the third one is licensure. Does your choice have licensure in your state? And if you're close to a neighboring state, then a lot of schools neighboring a border state will include licensure from that state as well. Okay, so you can sit there and choose somebody within those confines.